Okay. Thank you, everyone, for joining us. ACS and the Columbia Center for Contemporary Critical Thought are thrilled to welcome Professor Stephen Bright, joining us all the way from New Haven to discuss important issues of race and poverty and criminal justice. In addition to teaching courses on capital punishment at Yale, Professor Bright also serves as president and senior counsel for the Southern Center of Human Rights. He has developed a national reputation for his expertise on issues of capital punishment and the rights of the disadvantaged in the criminal justice system. He has received numerous awards for his work, including the ABA's prestigious Thurgood Marshall Award. And to top all that off, he is also an expert litigator, having twice argued in one cases before the United States Supreme Court on issues of racial discrimination and the composition of juries. And he joins us now, having just argued Foster v. Chapman, a third case before the Supreme Court involving the use of peremptory strikes to exclude African Americans from jury service. And we are also joined by our own Professor Bernard Harcourt, who will moderate our discussion. In addition to teaching criminal justice here, Professor Harcourt is the director of Columbia's Center for Contemporary Critical Thought, and he has extensive experience representing clients on death row, and has authored numerous books and articles on a variety of criminal justice issues. So now, please join me in welcoming Professor Stephen Bright to Columbia.
Thank you. Thank you. Thank you so much. Thank you very much, and thank all of you for coming here today to talk about something I think is of tremendous importance. And as I often say, no matter what kind of law you go into, this is something that is critically important because it goes to the credibility and the legitimacy of our legal system. Lawyers have a monopoly on legal services. It's a great way to make a huge amount of money, which is basically what the profession is doing for the most part. But there is a responsibility that comes with having a monopoly, and it's making sure that the system works for everyone. And what I want to say in the short time I have and ask you to think about and to do something about, I want you to think about what can you do as a lawyer, no matter what kind of lawyer you are, whether you're in a big law firm, whether you're a prosecutor, whether you're in the government, no matter what it is, what can you do about some of these problems? Because what I have seen over the last 40 years of practicing law is that in the criminal justice system, not just in capital cases, although these issues certainly come to the brightest and clearest relief in capital cases, but it's that the criminal justice system for the most part is rigged by race and poverty, and that most cases that are taking place have all the integrity of a professional wrestling match, and that the result of that is not something that any lawyer can be proud of. I'll just start with, we know in wrestling matches that one side, we know they're all choreographed to begin with. And one of the great problems that we still have in the legal profession is lawyers for poor people accused of crimes, all kind of crimes, whether people get lawyers at all in some of the, what some people would call minor cases. There are no minor cases in the criminal law. There are no minor cases. If you're arrested, if you're denied your liberty, if you lose your job, if you can't pay your rent, if you can't keep your car, your life is ruined, even though you may have the charges dismissed and you may walk free a week later. And so the ways in which this system, and the Ferguson report, and I see Justice and Ferguson have finally once again tried to work out a settlement to deal. What happens in Ferguson with the municipal courts, which the Justice Department pointed out was totally for revenue generation. It had nothing to do with safety of the community and enforcement law. It had to do with writing tickets to make money to support the municipality there. This is true of every municipal court, at least as far as I know, in the United States of America. In Georgia, we have a little town called Warwick, Georgia, population 450. Last year, the police department in Warwick, the police court in Warwick, the municipal court, collected $1.2 million in fines and fees and add-ons. 80% of the budget of this town all come from sending police officers out to just arrest people, mostly on traffic offenses, but on so many things that anybody can be arrested for: loitering, standing around, jaywalking, whatever it may be. And the people coming into this court don't even have lawyers. And then they plead guilty, they're put on probation, they can't pay, so they're fined, they can't pay, so they're put on probation to pay it in installments. And in fact, you're not supposed to be able to, Supreme Court cases say, that you can't lock people up for their inability to pay unless it's a willful failure to pay. And yet this routinely happens. We have debtors' prisons all over the United States of America. And there are two issues there. One, the lack of lawyers, and secondly, privatization of virtually every aspect of the criminal justice system. You pay to be on probation, $40 a month. You pay for your ankle monitor, $12 a day. You pay for the drug test, often ordered by the private probation company that makes the money off the drug test. But that's not what I'm here to talk about. But there are things that you should be concerned about. The great problem for a person accused of any kind of crime is the Sixth Amendment right to counsel. It's the most fundamental right you have. Every other right depends upon your right to a lawyer. You have a lawyer to assert all your other. If your lawyer does not know about the Fourth Amendment protection against searches and seizures and doesn't file a motion, then that right might as well not exist. If your lawyer is not aware of other things with regard to legal rules and things that you're learning here, constitutional principles that you're learning here at the law school, then those things don't exist for that client. If the lawyer doesn't do some investigation to test the state's case to see whether the state actually has a case to make whatever the most serious crime charged is, that is a capital crime in death penalty cases, to also investigate to see independently, is there a defense that can be raised to the charges? The ability to bring witnesses into court all depends upon a lawyer who's going to issue subpoenas and have witnesses there and present evidence. If there's going to be evidence about the life and background of the person who's facing the death penalty, if we're going to take into account all of the diverse frailties of humankind when we try to make that impossible measurement of, is this person, so beyond redemption that they should be eliminated from the human community? What kind of mental illness do they have? What kind of, how great are the limits on their intellectual abilities? What kind of life do they have? What kind of choices do they have? What kind of socialization? All those kinds of things. If that evidence is not there, then the jury can't do its job. And the outcome of the case is going to be a foregone conclusion. This has historically been the case in capital cases. When the South was getting a bad press for lynching people, the perfunctory death penalty trial took the place of lynchings. Basically, everybody was told, just hold off briefly. We'll give this guy a trial. We'll give him a couple of hack lawyers, all white, all male jury, and we'll have him on death row in no time. And of course, back in those days, you would often have a trial and be executed right after the trial was over. One case in Kentucky, the trial only lasted an hour, and the fellow was executed immediately after the trial. And the paper there said, well, there's some, it was kind of quick and it wasn't very fair, but at least we didn't lynch the guy. So we made some progress here. But we still have these kinds of legal lynchings today. Robert Holsley, executed by the state of Georgia right at the end of last year, represented by a lawyer who drank a quart of vodka a day during his capital trial. The reason the lawyer was drinking was not because he was so feeling the pressure of representing another human being in a capital case, was that he was about to be disbarred and indicted for stealing client funds. And he knew that his career as a lawyer, in fact, that his liberty was about to come to an end at the end of this trial. And in fact, he was indicted, he was imprisoned, and he was disbarred. This is not that unusual in Georgia. John Young was sentenced to death some time ago in Georgia, and not long after he was in the local jail there in Macon, Georgia, he sees his client there in the jail yard. He's there on federal and state drug charges. But the idea that a person could be sentenced to death at a trial at which the lawyer is drinking a quart of vodka a day fails to put on critical evidence that should have been put on, and is put to death by the state of Georgia, shows you just as one example of many of how bad the quality of legal representation is. I mean, that's the major consequence of poverty, is having a court-appointed lawyer. In 3 cases in Houston alone, and I'll just talk about, you know, if you want to talk about the death penalty, you have to talk about Texas, because that's where we execute people. Texas has carried out over 534 executions since the resumption of the death penalty in 1976. Harris County, Houston, Texas, has executed 125 people. 125 people sentenced to death in Harris County have been executed. That's more than any other state in the Union, except Texas itself, obviously. The other states that have had high numbers, which I put up there for you, only 2 other states over 100, but neither one has executed as many as Harris County. Oklahoma 112, and Virginia 111. And after that, we dropped down to below 100, and then there are no other states above 50 to be listed. This is in a 40-year period now in which we've had the death penalty in the United States. And the reason in Houston is 2 things. One, very aggressive prosecutors who seek the death penalty at every opportunity, or did for a while. Johnny Holmes, when he was the prosecutor there, and his successor, who ultimately had to leave in a scandal as prosecutors. And then absolutely terrible defense lawyers to represent people. 3 cases in Harris County alone where the lawyers slept, the defense lawyers slept during the death penalty trial. That's a pretty low standard for representation, that the lawyers stay awake during the trial. One judge, Doug Schaefer, the head of the criminal courts down there, when he was asked, how could you preside over a death penalty case when the lawyer sleeping was so obvious he was actually snoring during George McFarland's death penalty trial? And Judge Schaefer said, well, the Constitution guarantees you a lawyer, but it doesn't guarantee that the lawyer has to be awake. That's a strict constructionalist, if ever there was one. And I guess you could say George McFarland's trial, Calvin Burdine's trial, in which Joe Frank Cannon slept during his trial, a lawyer notorious for being a horrible lawyer, put 10 clients on death row, represented people in all kinds of other criminal cases, habitually appointed to cases by the judges there in Houston, even though everybody knew that this man was incompetent. 2 of his clients, Carl Johnson and Calvin Burdine, he slept during their trials. So you could also say, I guess that's what it means to have the dream team when you're trying in Texas. Carl Johnson was put to death despite the fact that his lawyer slept. Calvin Burdine was granted a new trial, but over a very bitterly divided en banc Court of Appeals for the Fifth Circuit, with some of the judges bitterly dissenting, saying that we should allow this execution to go forward, even though he only had one lawyer, and the one lawyer he had slept through substantial parts of the trial. So again, there's a whole lot more to be said about this. I've written some pieces about it. I commend them to your attention, but if we're going to have competent representation for people, we have to have structure, public defender offices. We don't have that in Texas and Alabama and a number of other states. We have to have specialization, people who specialize in representing people in capital cases and other kinds, juvenile cases, mental cases involving mental illness, that sort of thing. We have to have supervision of people. We have to have training of people, and all those sorts of things which are missing in many states. Finally, I would just say this in terms of prosecutorial selection, 2 things about it. One, Professor Liebman here has written an excellent article about how 2% of the counties in the United States, all the counties in the United States, 2% account for most of the people who have been sentenced to death and most of the people who have been executed in this country. So while we think of the death penalty as 31 states having the death penalty, it actually, like Harris County, is Exhibit 1 for how it's localized to Harris County, Texas, Jacksonville, Florida, Los Angeles, California, a number of counties in Texas, and that's where people are being sentenced to death today. And the other part of it, I would say, worth knowing in any criminal case, because as the Supreme Court has acknowledged, we have a system, not a system of trials, but a system of pleas. 95% of all cases in the state courts and 97% of all cases in the federal courts end with plea bargains. And that's how the convictions are obtained. In the death penalty cases, the two most important decisions are made by prosecutors. Do we seek the death penalty? And most of the time the answer is no. Overwhelmingly, prosecutors do not seek the death penalty, but they're the ones like in Harris County who do. And then secondly, is the case resolved with a plea bargain? This is Kelly Gissendanner, just executed recently in Georgia earlier this year. Ms. Gissendanner was part of a lover's triangle in which her boyfriend ended up killing her husband. The boyfriend was the one who actually stabbed the husband to death, had blood all over him. Ms. Gissendanner was nowhere near where the crime took place. So what happens? What classically happens in a criminal case? He agreed to testify against her, so he gets a plea bargain and gets a life sentence. She was offered, the state of Georgia was perfectly happy to give her a life sentence plus 25 years. Her very incompetent lawyer told her to turn it down and to go to trial. She gets the death penalty. 20 years later, she has been exemplary prisoner, has had tremendous positive influence on the guards, on their children, on the other inmates, on their children. You have the former Chief Justice of Georgia, you have the Pope, you have all of these people saying, for goodness sakes, this is not one of the worst, one of the most incorrigible offenders. This is not one of the most heinous crimes. This is not a case that involves a death penalty. The prosecutor says, wait a minute. She had an opportunity to plead guilty. She didn't plead guilty. The price you pay if you don't plead guilty is we carry out the sentence. And that's exactly what happened. And as she was singing Amazing Grace during the second stanza of it, as the lethal drugs were running through her body, she died. And so only lawyers could think that's acceptable. We're talking about the trial tax with plea bargaining. If you don't take the plea, you pay the price. Either life in prison or you can give you 5 years. If you don't take the 5 years, you get convicted. Of course, you get acquitted, you're out of there. But if you don't, you're going to get the life imprisonment. In this case, it was death. I think it's one thing to talk about terms of years and things like that. I think to put a person to death because they didn't take the plea bargain, and very often it's because they get bad legal advice, it's because they're intellectually limited and don't understand what their options are, they're mentally ill, for all those kinds of reasons. But here it was clear the state of Georgia would have been perfectly satisfied with a sentence of life imprisonment instead of the death penalty, and yet she was put to death. Let me switch quickly to race. I often say the criminal justice system is the part of society least affected by the civil rights movement. In the part of the country I practice in, which is the Deep South, many things have changed. I go to places where now there are African Americans on the city council or the county commission or on the school board, in the legislatures. My congressman was beaten to within an inch of his life on the Edmund Pettus Bridge. Now John Lewis is one of the most respected members of the House of Representatives. Things have changed. But I go to the courthouse. I go to the courthouses around the South, and I will tell you it looks like we're back in 1940 or 1950. Every person that's in charge of anything there, the prosecutors are white. The judge is white. The hack court-appointed lawyers waiting to process people through the system are white. The only person of color, often during a capital trial, is going to be the person sitting there at counsel table facing the death penalty. Even in communities with very substantial African American populations, we see all white juries. And so we see a court system that in no way reflects the number of people that are coming through it. A great deal of attention now to law enforcement relationships with the black community, as there should be, because now we know so much more because of cell phones than we used to know about how people are being treated and about people being shot in the back and people being shot over and over again and so forth. But what we're not paying enough attention to is what happens when people go into the legal system, and all of these discretionary decisions are made by almost always white people and usually white men. 95% of all the elected prosecutors, top prosecutors in this country, 95% are white. 73% are white men. And a substantial number of that 73% are mean white men. And these people have tremendous discretion over what to charge, what to offer as plea bargains, and a number of other things that go through the system. I just want to talk about one thing, jury selection, which is why there are no people of color on the juries in so many of these cases. And it's because the prosecutors strike African Americans during the process. As you may know, you bring in a group of people from the community, you ask them questions, do you know about the case, do you have any opinions on the death penalty, what do you know any of the witnesses, if you read about it, heard about it, you get all the people, you find out the people who can't be fair, and you thank them for coming down and send them home. And then with the rest that are qualified, each side exercises a certain number. In Georgia it's 10, what are called peremptory strikes, discretionary strikes that can be exercised theoretically for any reason. Used to be any reason at all. Now, any reason except race and gender can be exercised. And yet, everybody knows that they are exercised almost exclusively on the basis of race. And that prosecutors are going to strike the people of color. The Supreme Court in 1986, in a case called Batson versus Kentucky, said this is a disgrace. It's been going on. We've said don't do it. They do it anyway. So we're going to adopt this little test where we make the prosecutors give reasons for their strikes, and then we're going to ask the trial judge to decide whether or not it's a race-neutral reason or whether there was discrimination. Now let's just stand back for a minute and just think about basic high school psychology, all right? The judge is presiding here, lives here locally. We're talking about an elected judge and an elected prosecutor almost everywhere in this country except up in New England. And the judge is going to be asked to make two findings. One, that prosecutor intentionally discriminated on the basis of race. Now, in today's world, even though we know that goes on day in and day out, nobody likes to be accused of intentionally discriminating, and certainly nobody likes to have a judge find that. But secondly, the judge has to find that the prosecutor lied about the reason, and instead of giving the actual reason, which was race, gave a false reason, a pretextual reason for the strike of the juror, which also routinely happens, but nobody wants to admit. So you're asking the judge to find the prosecutor's a racist and a liar. And the fact of the matter is the judge was probably a prosecutor before he or she became a judge, and they probably struck all the blacks themselves. So they're not going to be too inclined to do that. Plus, the person who is the prosecutor was probably his or her chief assistant. I mean, I practice in jurisdictions where all the judges were prosecutors at one time. They move up to the bench. Their chief assistant moves up to prosecutor. He moves up to the bench. His chief assistant moves up to be the prosecutor. And so it's a group of people that tend to hang out a lot together, are good friends, go fishing together, go hunting together, and no telling what else. And so the likelihood that you're really going to find, the judge is going to find race discrimination very unlikely. The case I argue in the Supreme Court is sort of an example of what happens when these rare times when we pull the curtain back and we look at what's really going on. Timothy Foster, an African-American, intellectually disabled man facing the death penalty in Rome, Georgia, a little town up in northwest Georgia. And the prosecutor in his case, struck all the African Americans during jury selection. So he got an all-white jury. The victim was an elderly white woman. And the prosecutor argued to the jury in closing argument that they had to give Timothy the death penalty in order to send a message to the people who lived in the projects. Now, Tim Foster and his family lived in the projects. 90% of the people living in the projects were African American. So there's nothing subtle about that appeal to send a message to the people in the projects by giving the death penalty. And it's probably an argument that's going to resonate better with an all-white jury than a jury that has people of color on it. When we took over the case, we made a request under Georgia's version of the Freedom of Information Act to get the prosecution files. Usually after jury selection, the prosecutors would either shred if they have a shredder or burn if they just don't have a shredder. You just burn it with the trash. Their notes from jury selection, but in this case, they had forgotten to do that. Another prosecutor had taken office, and then another after that. And so we ended up getting the files, and lo and behold, what do we find but these records in the files? I should say that the judge accepted all the prosecutor, gave 8 to 12 reasons for striking every black. The judge upheld them all. So the Supreme Court upheld that, Georgia Supreme Court. So we get the case many years later. And we find, first of all, this is the list. There were 4 of these. The lists of all of the jurors who were summoned for the initial process. All of the black jurors are highlighted in green with a B beside their name, evidencing a certain race consciousness on the part of the prosecutor's office. These were circulated to everybody in the prosecutor's office. Nobody raises a question about why do we have, there's a little thing at the top that says green indicates black. Why do we have racially coded lists that we're sending around here? We found that the juror questionnaires, the prosecutors had made sure to indicate the people by their race, particularly all the black people are circled. The African Americans were referred to as B1, B2, B3, and so forth in the prosecutor's notes about the prospective jurors. And then the prosecution ranked the black jurors against each other. So that if they said Ms. Harge might be the best one to put on the jury if we have to take a black. If we had to take a black, maybe Ms. Garrett would be the best person to put on the jury. Ms. Garrett had the most potential of the blacks on the jury. So we've separated out the white jurors and the black jurors, and in the thought that maybe these African American might have to be on the jury. But the fact of the matter is Marilyn Garrett was never going to be on this jury because the prosecution had their list of definite no's. These are people who are not going to serve no matter what. This was done on the Sunday before jury selection started on Monday, and the first 5 people, Ms. Hood, Ms. Harge, Ms. Powell, Ms. Garrett, Angela Garrett, and Mr. Turner, those are all African Americans. And they are the priority strikes. And the 6th strike is a woman, Ms. Grinstaff, who had indicated she could not vote for the death penalty in any circumstances. She should have been struck for cause. No other people on there. So the fact was that Ms. Garrett was always marked to be struck, as was all these other people, and that, in fact, is what happened. The other part that came in, a number of things came out. I won't talk about too many of them, but this I thought was one of the smoking guns, was that they struck Mr. Hood because they said he was a member of the Church of Christ. And although Mr. Hood had been asked the questions that all jurors are asked, are you opposed to the death penalty? No. Could you consider the death penalty if we get to the penalty phase of trial? Yes, I could. Could you be fair in imposing the death penalty? Yes, I could. Do you have any reservations about imposing the death penalty? No, none whatsoever. But they still struck him, and they said we struck him because he was a member of the Church of Christ, and the Church of Christ is so opposed to the death penalty that anybody who's a member of the Church of Christ is going to vote no on the death penalty. And here in the prosecutor's own handwriting, we have a note in the file that says Church of Christ takes no position on the death penalty. They knew good and well they were lying when they said that. And that was one of several lies that were shown up by these notes. And then, of course, I said in the closing argument, the argument was deter people in the projects. So we go back to court and we say, look what we have now. Look at this evidence of intentional race discrimination. Look at the lies that were told by the prosecutors in this case, and give Timothy Foster a new trial where we'll have a jury selection process that's fair and impartial. Very seldom are you ever going to get these notes, but these kind of considerations go into jury selection in every criminal case. Everybody knows that the prosecution is going to strike. Some lawyers tell me, oh, I strike through the blacks when I get the list, because I know the prosecutor is going to strike them, so I just go on and do it. And so, as many people have pointed out, Justice Marshall, Justice Goldberg, most recently Justice Breyer, peremptory strikes are just a license to discriminate if we're really serious about it, Supreme Court every now and then throws in one of their cases, they say, we have engaged in unceasing efforts to end race discrimination. Every one of those cases, they've done something to permit race discrimination, like McCluskey versus Kim. But they say that anyway, which is sort of the Orwellian world in which we live. But if they are even slightly serious about that, then they have to do away with peremptory strikes, because there's no way Batson has been a failure. This is, as I said, this is just a case where serendipitously we get this information that the prosecution has intentionally discriminated on the basis of race, and there's no guarantee that we're going to win this case. So we will see. It was argued in November. Most of the cases argued before it have now been decided, so I think probably end of this month, first of next month, we'll get a decision in the case. But the larger point is not what happened in Tim Foster's case, it's well, this is happening in every case. And we're in states like Georgia with almost 30% African-American population, Alabama about the same, Mississippi even higher, 33%, and yet we're still seeing these cases tried by all-white juries. So I'll answer questions about any of this that you like, the time we have left.
That was terrific. So let me see if I can get some sound here. All right, well, let's just stay here.
Does that work? I think this may double it up. No problem.
So I just wanted to start maybe by asking you what it was, how receptive were the justices to the argument? So what was it like arguing there, and individually? Did you sense that they were understanding the argument, favorable to it, that they wanted to resist it, or what was it like?
Well, you know, these are fairly powerful facts, at least I hope you think so, looking at them. The argument was set for Monday morning, November 2nd. On Friday afternoon, we got an order from the Supreme Court. This is remarkable, in my experience in any court, saying we would like for you to be prepared to address another issue that no party had raised in the case. The state hadn't raised it. It was not an issue in the case, wasn't an issue in the court below. But that's pretty remarkable. To throw into your lap on the Friday before the Monday argument a new issue, but of course you had to research it over the weekend. The clerk had told me when he called me to make sure that I'd gotten this order, because the order literally had been cut at 2 o'clock in the afternoon. I was in a moot court, so I didn't find out about it until 4 o'clock. Be sure we knew about it. I said, I don't think the court's going to ask you about it, but they just want you to be prepared. When we started the oral argument, I literally had maybe 5 words out when Chief Justice Roberts said, Mr. Bright, we'd like you to address the issue we raised in our order on Friday. So we spend the first 5-7 minutes of the argument arguing some procedural issue that nobody has raised before, and then just as that's sort of coming to an end and Justice Sotomayor is saying, this is the most confusing thing, I don't even know what this is about, Justice Alito decides that he's found now a procedural issue that maybe will block consideration of the merits. This, again, has not been raised by the state in its brief. So we spend another few minutes on that. And then finally, we get to the merits. And this is, of course, what the law is all about these days. We don't talk about the merits. The public thinks these issues are being decided on the merits, that when appellate courts rule, it's on the merits. It's not on the merits. It's on a bunch of technical, procedural rules that are not the product of Hamilton and Madison and Jefferson. They're the product of Rehnquist, O'Connor, and other more recent members of the Supreme Court, basically to trip people up and to be able to avoid getting to the merits of cases. And they may be successful in this case in doing it. It'd be really dishonest if they did, particularly on Alito's point. The state conceded our side of it in their argument. Once we got to the merits, once we started talking about what happened, Justice Kagan said to the state, as the very first question to the state, isn't this the clearest Batson violation we're ever going to see? That's a pretty good question if you're on my side. You know, I like that. Can you ask that again? You know, didn't hear it. Nobody really defended what happened. Justice Scalia said something about, well, the trial judge, I mean, he was there, he saw it, we have to defer to him. And Justice Kagan didn't even wait for anybody to answer. She said, well, the trial judge didn't know any of this stuff that was in the record, in the file, at the time of the trial. This came out 10 years after the trial. So what the trial judge knew didn't matter. He did not fight her on that or anything else much. And Justice Alito tried again to play a little bit around with the procedures, but even he was bothered. I mean, one of the reasons for striking Ms. Garrett was that she was close in age to Mr. Foster. She was 34 and he was 18. And the state accepted a number of white people who were less than 34. And in fact, a white man who was 21 served on the jury. So that reason didn't really seem to be that legitimate. The state's argument, though, was that, well, if any reason was legitimate, give 8 to 12 reasons, surely, you know, I mean, surely if you just throw the ball, you're going to hit the barrel at some point. That if any reason, and some courts have held that if any reason is race neutral, it doesn't matter that the others aren't. But at any rate, so I don't know. The court was if we get past the procedural issues, we pretty clearly win on the merits. But that's what we're waiting to see.
How was Kennedy and Roberts?
I think Justice Kennedy indicated that he was pretty troubled by it. The state gave as their reason an oral argument, and in their brief, they said the reason the state had all these notes that we had discovered and all this information on the black jurors, they didn't have this information on the white jurors. It was they only investigated the black jurors. They only wanted to have reasons for the black jurors. They weren't really, apparently they just thought that all the whites would be okay. And the argument that the state made was, well, this was in case there was a Batson challenge, they wanted to be ready for it. So they wanted to have all this information about the blacks. And I think it may have been the chief who asked the question, said, well, the lawyers at trial never suggested that was the reason. And they didn't, in fact, nobody suggested it until you filed your brief in this court. And aren't the reasons supposed to be the reasons that were actually the reasons the trial lawyers had at the time they made the strikes, not reasons that some appellate lawyer thinks up 28 years after trial and says this is the reason? The other argument that they made was that the state was confused about what Batson held, or it's not very complicated if you've read it. It's not a very complicated decision, but that they were confused about it, and Justice Kennedy said, well, they may have gotten the law wrong, but they got it wrong. And, you know, it's a capital trial, and, you know, you can't really get the law wrong. I felt like Justice Kennedy was seeing the merits, at least our way. I may be wrong, but that was my thought about it.
Is the absence of Justice Scalia going to play a role in the decision in the case?
No, if the worst case analysis, now last time I was up there was a case called Snyder versus Louisiana, which was another Batson case in which they had struck all the African Americans in Jefferson Parish, Louisiana, from Alan Snyder's case. And to my complete amazement, I got hit pretty hard with some questions by Justice Alito right at the start of the argument. And we actually won 7-2 with Justice Alito writing and Thomas and Scalia, of course, dissenting. So the case doesn't necessarily have to be a 5-4 case, but if it is, if Justice Kennedy goes our way, we would have won 5-4 with Scalia on the court. With him gone, we'd win 5-3. If Justice Kennedy goes the other way, he would join the right-wingers. And it'd be 4-4, which would affirm the decision below. We would lose. So actually, Justice Scalia doesn't affect. One bit of speculation on why the decision didn't come out yet was that maybe Justice Scalia was writing a dissent, and now it's got to be reassigned to Justice Thomas or somebody like that. That's an optimistic view of it from our point, but anyway.
So on the larger issues of kind of litigating race in the death penalty and across the criminal justice system, I take it that there were some moves in the 1990s to come up with a Racial Justice Act that failed at the national level. Have you seen any changes in the last decade or 15 years or 20 years that are some signs of movement in the right direction at a systemic level to address the issues of racial discrimination?
No, there was one encouraging development it's worth looking into. North Carolina is the only state that ever passed a Racial Justice Act. We tried to get the Congress to pass that after the McCluskey case came down, in which the Supreme Court said that racial disparities are inevitable and didn't create any sort of violation of the Equal Protection Clause, and that the Eighth Amendment, all it requires is procedures that would minimize the risk. It didn't matter whether the procedures worked or not. You just had to have procedures that would minimize the risk of race discrimination. Everybody knows it's going on. So the idea was to try to overrule those decisions, that decision. North Carolina was the one state that passed and had evidentiary hearings on race. And the most interesting thing of that was that in the study that was done, they looked at every single capital case in North Carolina and the way in which the prosecutors had used their jury strikes, and found that you're twice as likely to be struck if you're a person of color than if you're a person who's white. You know, it's one thing to have 10 people and the prosecution strikes 4 out of 10, 100% of the blacks, but 4 out of 10. And that, you have a pretty good idea what's going on, but you don't know for sure. But when you aggregate all of the cases that have been tried over 40 years, and you put those numbers together, it doesn't really, chance does not explain the enormous disparities that basically at every opportunity to strike a person of color, the prosecutors in North Carolina were doing it. And one of the interesting things that came out there, one of the Illinois courts had said in an opinion sometime before this, you know, now we come to the charade called Batson, where a Batson issue was raised before them. And surely every prosecutor is issued a little manual of handy-dandy race-neutral reasons or time-tested race-neutral reasons. They were being sarcastic when they said that. But what came out in the hearings in North Carolina was that the North Carolina District Attorneys Association had a statewide training program called Top Gun 2, in which they had a session called Articulating Juror Negatives, in which they distributed race-neutral reasons that you could give when you struck blacks. Now, as I said a moment ago, you're supposed to give the reason you actually struck the person. So a reason on a list that you take to court with you before you've even seen the jurors couldn't possibly be, I don't think, or maybe some of you have some way of looking at this different than mine, but as far as I know, that couldn't really be a reason that you used because you don't even know who you're going to strike yet. And yet what Judge Weeks found in that case was that the prosecutor who denied going to the training program, and then they subpoenaed the CLE credits and found out, in fact, the prosecutor had attended that training program and that session, had used those reasons, and the reasons were all these demeanor reasons, that the jurors looked at the floor, that they weren't attentive, that they were bored. I've always said, what a great reason. You know, I've picked a lot of juries in my life. I've yet to pick one where the prospective jurors were riveted by the jury selection process. You know, have you ever been summoned for jury duty? Standing around all the time, waiting here, waiting there, go down the hall, come back, do this. It's boring, for goodness sakes. Everybody's bored. So, of course, that's a race-neutral reason. It's not really a race-neutral reason because it applies to white people just as well as to black people, and hopefully a lawyer would say that. But unfortunately, one of the things that I think is so discouraging in this area is that because the courts, the North Carolina courts have never, North Carolina Supreme Court has never, ever found a Batson violation. Not a single one. So if you're in North Carolina, you think, what's the chance, except for this case, this Racial Justice Act case, what's the chance of success? If you make the claim, it's going to alienate, you're going to get the DA's going to get mad at you. You saying I'm a racist? And I tell you, yeah, you can say, yeah, you're racist. You struck this guy, and it's on the basis of race. If you're not going to pony up to that, don't make the challenge. And so a lot of people don't want to make the challenge. Of course, the other thing is they think it's going to be fruitless. So why get everybody mad at you if you're not going to win anyway. But that's not a very good attitude, because we're never going to change things if that's what we do. I mean, we have to raise these issues, and we have to challenge the reasons, and not only make the motion and challenge, but then try to contest whatever the reasons are. Like, for example, the person was bored. Well, everybody's bored, Judge. That's not a race-neutral reason. Or a particular thing. A lot of times the prosecutors will they'll tell things about the jurors that are not. Let's bring that juror in here and let's examine the juror about that. I don't think that's true. I don't know if his son was prosecuted or not. Let's get him in here and find out. Let's find out what he thinks about it, whether it'll keep him from being fair and impartial. But that kind of aggressive litigation of bets and motions does not go on. And the courts, the trial judge, great deference to the trial judge, and the appellate courts, a clearly erroneous standard, a very, very difficult standard to meet in doing it. But it really undermines, it's in the Snyder brief, it said, the black people in Jefferson Parish know that they are disenfranchised. They are not a part of the criminal justice system. They never participate as jurors. We could show that. They never, ever participate. 15% of the population, they struck them every time. And then not only that, the white people know it too. And at some point, the court just doesn't have any credibility or legitimacy when it's a court that only operates for one part of the community. And particularly when it's a court that is having such a heavy-handed, drastic impact on the minority part of the community, when it's sending and disenfranchising all these black youths and men so severely, it just doesn't, that just doesn't pass the muster, if anybody was paying attention. And I think the biggest problem here is that for so many people, the criminal courts are out of sight and out of mind. It's all poor people, overwhelmingly racial minorities, and people, that's why I say every kind of lawyer has to pay attention to what's going on in the criminal courts and how we're treating the poorest people in our society who come into the criminal courts and are not being given legal representation, are just being processed through that court, and decisions being made all the way through by people who have, at best, no racial sensitivity whatsoever, and at worst, strong racial biases, which are why. I mean, we had a court in Georgia, Greene County, Georgia, where you could plead guilty to a felony and they put you on probation. They didn't care. All they wanted to do was disenfranchise you. They wanted to make sure they got all the blacks disenfranchised so they couldn't vote. Of course, they'd revoke you. They'd put you on probation and they'd give you a fine you couldn't pay and conditions you couldn't meet. And, within 6 months to a year, they'd revoke you and send you off to prison anyway. But the first goal was disenfranchise you. And of course, that's one of the big effects of our criminal justice policies, is disenfranchising people of color and getting them out of communities.
Thanks, Steve. So I've got a bunch more questions, but I want to give opportunity to others to ask questions as well. Yes.
So thank you. I think it's fair that a great many of us are infuriated by this state of affairs, and you sort of started your remarks with a sort of call to action. And so I was wondering if you could say a few words about, for those of us that are at least not at first or perhaps never going to practice squarely on criminal justice issues, what are some of the things that we should do and keep in mind?
Well, change your mind and practice on criminal justice. That's my advice. If you want to do something with your life that's meaningful, and so many lawyers, and I have a lot of my former students, I've been teaching 25 years, and I have a lot of my students come back and they tell me about how empty and vacuous and materialistic and obnoxious their partners are, and just how awful it is, I said, well, I told you that when you were in law school. I don't know why you're complaining to me. I told you if you went, that's what you were going to find. Sure enough. Elie Wiesel said when he won the Nobel Peace Prize, our lives are not our own. They belong to those who need us desperately. And if you want to go deal with some desperate needs, if you want to go deal with some people who desperately need you, it's in providing legal assistance to poor people accused of crimes. There are a lot of other desperate needs, but that is a very desperate need in this society. And there's a real need for people who will devote full time, devote their lives to dealing with these issues, because I will tell you, good lawyers make a tremendous difference. One of the things that I have noticed in fighting these battles is that they will do anything to fight off good lawyers so they can give people bad lawyers, like these lawyers in Houston that I was talking about, because it's like shooting ducks in a barrel. If you're the prosecutor and you've got some sleeping lawyer on the other side, you can get away with murder, literally. And so it's really important to have people, not just to delve around and but everybody in my school tells me, oh, we all want to go off and work on policy. Well, that's great. I mean, policy needs to be worked on, but you need to know what you're doing. And there's no, people need to represent clients and have cases to find out what's really going on. I see so much of the policy stuff that has nothing to do with the reality in the courts. Nothing whatsoever to do with the reality in the courts. Because the reality of the courts is poverty, lack of lawyers, lack of competent lawyers, lawyers who are just processing people as opposed to lawyers who are representing people, judges who are about anything except justice, mostly about getting reelected. And so we really need to get down and deal with the realities of what's going on in the system. But if you are, at wherever you are, you know, there are all kinds, I mean, you know, and I do see some outstanding work done by many New York law firms who come down and take these cases and devote the same resources to them that they do to their private clients, and are able to show that people are innocent, show that people's mental illness is such that they should have been sentenced to death or whatever it may be. So, I mean, you know, John Thompson is alive today. I can't remember the name of the firm, but a New York law firm represented him. He was literally within 2 weeks of execution when they found the blood test that showed that he was not the person who did it, that he was innocent. And that was because they left no stone untouched. So there's something for everybody. There's something for everybody. But you got to go to the legislatures and the people like that and say, we've got to set up public defender systems, we've got to have structure, we've got to have... New York is horrible. New York is absolutely horrible. I mean, here in the city, in the boroughs, you got Bronx defenders and groups like that, but you go out around Syracuse or whatever, it's horrible. Horrible. People don't get lawyers for a long time. You get arrested. I don't know how many of you have been. I won't ask for a show of hands. But I will tell you, if you get arrested, there are two things you want very quickly. One, you want out. If you've ever been in the drunk tank, as I have been, or the intake area, as they call it, where I've been, you want out. There are people vomiting. There are people who are crazy. There are people going through DTs. There are people going through all sort of other... I mean, this is not a welcoming group of people who don't sing Kumbaya there. You want out. And what do you want? You want a lawyer to get you out. And if you're a person of means, you'll have a lawyer and you'll be out within a few minutes. If you're a poor person, you may stay there, Diego Moran, facing the death penalty in Del Rio, Texas, ask for a lawyer 8 months before you saw a lawyer. 8 months. All these things that should be investigated. All the witnesses who should be talked to. Well, the trail is ice cold by the time they finally give him a lawyer. 8 months after he's been arrested. And he's been sitting in the jail, and think about what that would be like. To be arrested and thrown in a jail, and you want to know, what am I charged with? What are my chances? When am I going to court? How does this process work? All this, nobody will tell you. You're just like being dropped down in a foreign country where you can't speak the language, and you have absolutely no idea. It's just a Kafkaesque. You know, I had a client, friend Billy Moore, sentenced to death. The judge, you know, you'll be executed on such and such a day. God have mercy on your soul. The lawyer never bothered to tell him that there was an automatic appeal. So as the day drew closer, Mr. Moore thought he was going to be executed. And when the day came, every time they opened the cell block to come down the hall, he thought they were coming to take him to the execution chamber. That's why counseling. You see the importance of just counseling with clients, just sitting down and telling people what their legal situation is, even if you can. I represented more than a few people that I've ultimately stood and watched when the state tied them down and put them down. But to be able to help people and guide people through that process and give them counseling and advice and explain to them and their families what's going on. I mean, that is an enormously valuable task that lawyers can provide, and the failure to do that in a lot of these cases, the failure to even give people lawyers to do that, is unconscionable. It's unconscionable.
All right, I think we have to give up the room. So, and we want to give a great thanks to Steve Bright.
Thank you for coming. Thank you for coming.